Hey everyone, Mark Merkel here, president of Convention of States. I have some very exciting footage for you. Right now, what we're going to show you is what is literally, in my opinion, the definitive case for Convention of States. This footage is from an Ohio hearing that took place on February 6th of 2024, and it features my co-founder, my good friend, and one of the nation's greatest constitutional experts, Mike Farris. Mike Farris founded the homeschool movement in America. He's been a constitutional attorney for decades. He's had many cases before the Supreme Court. He was recently the president of Alliance Defending Freedom, the world's largest religious liberties organization. During that time period, by the way, 13 cases before the United States Supreme Court, won 12 of those, including participated very heavily in the Dobbs decision overturning Roe versus Wade. So this is a man who knows his stuff. I want you to watch this footage, get the definitive case for COS, and then stick around afterwards for some additional footage. I know you're going to enjoy the show.
Dr. Farris, thank you for being here.
Thank you, Mr. Chairman, ranking minority members of the committee. Thank you for the opportunity to be here. I am the co-founder of the Convention of States Project, a lawyer, been in practice now my 47th year. I've argued dozens of cases, constitutional cases, in appellate courts, including the Supreme Court of Ohio, 2 cases in the Supreme Court of the United States. And I have litigated an Article 5 case on the amendment process back in the late 70s, early 80s, in a case that made it to the Supreme Court of the United States on the question of the extension of time on the Equal Rights Amendment. I represented 4 Washington state legislators in that case. So I'm one of the few lawyers in the country who've actually litigated an Article 5 case. I've also taught constitutional law at Patrick Henry College. 2 of my former students are now state solicitor generals, Indiana and West Virginia, and 5 of my students have clerked for the Supreme Court of the United States. I do that to say that a lot of lawyers claim to be constitutional lawyers, and my question to people making that claim is, show me the number of laws you had declared unconstitutional, and then we can talk. And so the constitutional issues in this case, sorry, I'm used to this, in this legislation, can be addressed today perhaps by asking 3 questions. Why did the founders create the process that we're seeking to use here? The second question is, do the current circumstances that we face in our country align with that purpose and that process? And third, is the process safe? And I'll briefly address all 3 of those questions. It was at the end of the Constitutional Convention process in the last week where George Mason observed that the proposed version of amending the Constitution that was in place at the time had a blind spot. And that is, all amendments were going to be proposed by Congress and all would be ratified by the state. And his speech to the convention basically said, Congress is never going to propose an amendment that limits its own power. And the founders in that day probably said something like, we hold that truth to be self-evident. If they were around today, they would say like, duh. And meant the same thing, and they immediately proposed the change to Article 5 that we now see, to give the states the ability to propose amendments for the express purpose of limiting the power of the federal government if the federal government gets out of hand. That's the reason we had it. It was one more layer of the checks and balances process. We don't want any agency in government, we don't want any level of government having too much power, and the ultimate ability to amend the Constitution essentially unilaterally, not by one state, but by ultimately 3/4 of the states, was a check on the misuse of federal power. That's why we have this process. So that takes me to the second question. Do our current circumstances align with that purpose? Well, I could give you a couple hours worth of reasons that would be true, but I'm going to do 3 and do them briefly. First, the debt. We are experiencing debt that's in the 30s of trillion dollars, and if it's not exactly there today, it'll be 40 trillion all too soon. It's just out of control by anybody's estimation, and that's calling the debt that's on the books. If you take off the book debts, like all the money that's been borrowed from the Social Security system and not paid back, the actual number is closer to $150 trillion, an unimaginable number. And we've done that by spending for things that are not within the competence of the federal government. And that all comes back to a Supreme Court case. If you want to know which case caused all this, the Butler did it. It's United States versus Butler, where the court said Federal spending was not limited to the enumerated powers. If federal spending was limited to the enumerated powers, we would essentially have no federal debt. We would certainly not have the kind of federal debt that we're looking at today. I'll take a second example, education. Years ago, I was litigating a homeschool case in New York, and I walked from the State Department of Education, past the city offices, past the regional office called BOCES, down to the federal offices where the litigation was going on. And I realized that every single level of government that I had just passed had a Department of Education. We do not get more services for kids. My dad was a retired public school principal. We don't get more services for kids by having multiple departments of education. We get more bureaucrats. The founders never gave education as an enumerated power to the federal government. They take our money from the states, they take it to Washington, D.C., they send a small portion of that money back to the states with strings and effectively run the educational programs of the schools. About, on average, 5% of school funding comes from the federal government, and 55% of the rules come from the federal government. It is an out-of-control situation. If we returned that whole process, took it away from the federal government, reduced the power and jurisdiction of the federal government, we would have that problem solved on that particular issue. We're getting the feds out of it and get back to just state and local government dealing with education issues. Third example, one is a special favorite of mine ever since I ended up getting an LLM in Public International Law from the University of London, is the treaty process has just gone awry in our country. Our country adopts about 200 treaties a year. 95% of them never are sent to the Senate for ratification. Some years a little more, some years a little less, but the vast majority of treaties are signed either by the president alone or by the Secretary General of the not the Secretary General, but the U.S. Ambassador to the UN or some other diplomatic person. We call them executive agreements. That's a term that the Supreme Court and the State Department collectively made up. In international law, all executive agreements are treaties, but we do not treat treaties the way we do. The reason I do this, I'm sure you're getting inquiries from constituents about the upcoming WHO treaty that President Biden has indicated that he's going to sign as an executive agreement in April. And that treaty turns jurisdiction over from the states over pandemics to the federal government under the general supervision of the United Nations World Health Organization. And so that's the way treaties work. Under the necessary and proper clause, once a treaty's been adopted, then the power to implement that treaty goes to the agency that adopted it. That's the federal government, that's Congress. And so what we saw in the COVID pandemic, the states had the ability to vary their processes. We lose that under this treaty, and we lose it without so much as a vote in the Senate. We can stop the federal government from doing this end run around the provision of the Constitution that says all treaties should be ratified by the U.S. Senate by a simple fix that effectively overrides the case that the Supreme Court made on this, which was called United States versus Pink. So those are three examples of how we need to impose fiscal restraints on the federal government, impose limitations on the power and jurisdiction of the federal government. The third topic you'll hear about from others under the application that's before you is term limits on federal officials. I'm not going to address that separately. I'm going to address just briefly the third question: is this process safe? The original process that we were given was checks and balances against the federal government, but there are checks and balances built into this process that prevent this process from going awry as well. In order to have a convention, you have to have 2/3 of the states agree on a topic for the convention. The application that's in front of you has been passed verbatim by 19 other states. And Kansas is maybe 20, but that's a long story. But 19 for sure. And so there's no question about aggregation, but we can't add that to other treaties that have been, or excuse me, not treaties, but applications have been proposed over time. There have been 450 applications for a convention over the course of history. The vast majority of them are still valid and in effect. And if 34 applications on any old topic was okay, then we'd have had a convention a long time ago. That's never been the case. We've always had the rule that you have to have agreement on the topic. So when we get to 34 states, agreement on the topic, then you can have a convention. Well, what's to prevent the convention from changing the rules at the time? The question arises because the argument's usually made. The original Constitutional Convention was a runaway convention. They didn't stick to their topic. Why will this happen? Well, that's just simply a historical lie. That's not what happened. I wrote the definitive answer to that argument in the Harvard Journal of Law and Public Policy. You can get it online for free. I have a few copies here today if you'd like to see them or have them. And it's called Defying Conventional Wisdom, How the Original Constitutional Convention Was Not a Runaway. And if you put my last name Farris in and the phrase Defying Conventional Wisdom, you can get it for free on the internet from the Harvard Journal of Law and Public Policy. The basic answer is the states called the convention, and here's what the states told their delegates to do. Render the federal constitution adequate for the exigencies of the union. The phrase, only amend the Articles of Confederation, comes from a resolution by Congress that has the power and effect of a National Pickle Week resolution. It was basically Congress giving their opinion because under the Articles of Confederation, Congress didn't have any power to call any conventions. They had very limited power. And so the states called the convention. They told them to render the federal constitution adequate for the exigencies of the union, and that's what they did. The idea that they were only supposed to amend the articles is a flat historical lie that defames the Constitution of the United States. People who call themselves constitutionalists on the one hand, and then claim the Constitution was a result of a runaway convention, are engaged in intellectual schizophrenia at a pretty deep level. The checks and balances say, start with 2/3, agreement on the subject matter. And then you go to the convention. It's one state, one vote. It can't be proportional representation because that's a Congress, not a convention. A convention of states, every convention of states that has ever been held in this country, and there have been many, it's always one state, one vote. In fact, it's a term of international law. Every international convention is one state, one vote. We call them states in international law. And that phrase carries on. It's one state, one vote. That's a structural change. But 26 states, a majority, at the convention can approve a proposed text. Then it goes to the state legislatures. 38 states have to ratify. Now, that means if a single house in 13 states vote no, it's over. You lose because it requires 38. So 13, one house going off and saying, no, we don't want this, that defeats that state. So 13 no votes in 13 chambers, we're done. The only way you can do this is if you have a sensible amendment, because it is very hard to do something good in this process. Very hard. Not impossible, but very hard. It is impossible to do anything crazy. Just you can't get it done. The structure that's in place is so solid. You cannot do something crazy. Now, there are two kinds of groups that are saying the opposite. One on the far right, one on the far left. On the far right, they're basically functional anarchists. They don't trust any government whatsoever. They don't trust this government. They don't trust their city council. They say every government's illegitimate. They're all doing the wrong thing. It's all bad. We can't run a country with functional anarchists in control. Just doesn't work. And they're saying that the checks and balances won't work because they don't trust any government at any point in time. The other group on the left, they're people that love centralized government. The more centralized, the better it is, including world government. They love things like turning over our pandemics to the federal government under the supervision of the UN. And so those people are also singing this runaway convention. You can't control it. You can't control it if your goal is functional anarchy. You can't control it if your goal is massive centralized government. Their arguments flow from their premises. Their premises are dangerous to this country. We do not want functional anarchy. We want a nation that works. And we do not want centralized runaway government. And that's what we've got in Washington, D.C. right now. We need to do the kind of government that works. That is a constitutional republic where there are limited powers at each level of government and there are functional checks and balances. The founders of this country gave every member of this committee and every member of this legislature authority to act. with that authority to check the power and abuse of the federal government, I suggest that you have the moral responsibility to do so. I would encourage you to vote favorably in this legislation. And I'd be happy to answer any questions that anybody might have.
Thank you for your testimony. Representative, again, with a question.
Thank you, Mr. Chairman, and thank you, Attorney Farris, for being here today. Certainly appreciate you bringing, your testimony with regard to HJR 3. I want to say you brought up a lot of different points, some that, specifically relate to the joint resolution, but then some that don't necessarily, but also just provides some imagery so that we all could understand. So again, just want to say that I appreciate that. You brought up a point about, is this safe? And I appreciate that question, but it led me to start thinking in another direction. So my question for you is, with regard to like the state legislatures, do you know if within this bill there are any safeguards so that we can kind of oversee some of the processes and all of that as it relates to the conventions and actions and things like that? So any input you could provide, I would appreciate.
Certainly. There are a number of states that have passed pieces of legislation. Some are doing it as legislative rules that give the state legislature authority to control the actions of your delegates. They are meaning yours, not just Ohio's. They are Ohio state legislatures delegates. They represent you. And so just like at the original convention, at the original constitutional convention, New York gave its delegates the instruction, all three of you have to be present to vote for New York. If you're not all there, you don't get a vote. Two of them got mad in July and left. Yates and another guy left Alexander Hamilton there. Hamilton debated, he never voted again because the state's instructions wouldn't let them do it. Delaware gave their delegates instructions that said, you can't agree to a government that denies the equality of the states. That's where the U.S. Senate, the compromise came in, is because Delaware couldn't vote for it unless there was equality of the states in some important fashion. That they thought that the Senate was with the fulfillment of that, and that's how we got an important factor in how we got the bicameral legislature. So yes, states can and are in this process giving their delegates instructions. You can give them a variety of instructions. We have model rules, we have model legislation on that, and yes, you can control them entirely.
Other questions for the witness? Representative Brown.
Thank you, Chair. Article 5 of the Constitution states, and I'm just going to read it so that there's no mistake, the Congress, whenever 2/3 of both houses shall deem it necessary, shall propose amendments to this Constitution, or on the application of the legislatures of 2/3 of the several states, shall call a convention for proposing amendments, which in either case shall be valid to all intents and purposes. Now, if I heard you correctly, you were talking about the convention will be limited to a topic or certain topics. Doesn't this language fail to impose any limitations on any topic which may be raised in a constitutional convention under Article 5?
The question is, what constitutes a call? I'm a constitutional originalist, and so the question, the phrase that's there is the word call, shall call a convention. What is it? One of the factors, a call of a convention contains three things. It contains a subject matter, it contains a date, and it contains a time, a place rather. So a call will have those three elements. The topic, the lessons of history, if we've had 450 applications, and if it didn't matter what the topic was, we would have had a convention on all kinds of things. For example, right now today, if you add the plenary applications, mostly coming from the 1700s and 1800s, but there are 13 active calls for a plenary convention today. That is a convention that can consider anything. And you add them to the number of right to life amendment applications that have been exerted. You could have a convention on right to life right now, today, but you can't add them. The same thing is true. You could add them together and get the 16th Amendment reversed. You could add them together and get one man, one vote reversed at the state level. There are all kinds of things if you add them together, but that's not the rule of history and that's not the rule of law. Legislative history is part of what the word call means. And we have definitively settled as a matter of legislative history. We have multiple times had the necessary number for a call if subject matter didn't matter. Now, the litigation that I did in the ERA case held, and recent court decisions have affirmed that case, that is, you can't change the rules in the middle of the stream. If you start out saying you're going to have 7 years for ratification, you got 7 years for ratification. You can't change the rules in the middle of the stream. And the same thing is true here. If you start a convention for the purposes of the 3 topics that we have here, you can't change the rule and add a 4th or a 5th or a 9th. You stick to the topics at hand. And that's the way it's always been, and that's the way it will be.
Follow?
Thank you, Chair. So is it your testimony that there is no possibility that if such a convention were called, the proceedings could evolve from a mere suggestion to amend the Constitution into a proceeding where the Constitution may be totally eradicated and replaced by an entirely new Constitution?
That cannot happen, Mr. Chairman, I'm sorry, Representative Brown through the chair. No, it can't happen as a matter of pragmatism and as a matter of law. The matter of pragmatism is whatever comes out of this convention, whatever comes out, has to be ratified by 38 states. Because we're not operating outside of the constitutional convention process in Article 5. We're operating within it. If the states, using the power, the implied power of the Declaration of Independence, basically held a revolution and said, we want to have a new thing altogether, and enough states showed up, you could try to do some kind of radical exercise like that. That can't happen inside the Article 5 process. You have to have 38 states ratifying. And anybody that monkeys with the First Amendment, the Second Amendment, the 13th Amendment, the 14th Amendment, the 19th Amendment, lots of amendments, lots of provisions, the separation of powers, the 2-term limits on the president. There's lots of things that would be so clearly voted down that we don't have to give them serious consideration. It's just, we have to breathe and take a little bit of common sense to it. Moreover, if somebody tried that, I personally guarantee, I at least will file the case and challenge them. I filed the first case against the abuse of the ERA and I won, and I'll do it again if that happens.
Follow.
Proceed.
Thank you for your response. I appreciate it. I have some questions about how this would operate. A convention, for example, with regard to the selection of delegates to a convention. I suppose one option would be to let the state legislatures choose delegates from their state to the convention. Another option might be for Congress to require elections for delegates, which could occur in either nationwide, statewide, or perhaps House district races. So what is your understanding or your belief as to how delegates to such a convention would be selected?
They will be selected by the legislature. That is a certainty. Because what it is a convention of states. That's what the founders called it. The first application was from Virginia in 1788. Even before the Constitution had been ratified, but the government wasn't operational. And they called for a convention basically to give us the Bill of Rights. And in that document, they call it a convention of states. That is a term of art that has a fixed and knowable meaning. And it's the legislatures that do the calling through, they do the application. The states control the process, just like the convention they came out of. I gave you the examples of New York controlling its delegates, Delaware controlling its delegates. It is the delegates of this state legislature. There is no doubt about it. Can people argue anything? Sure, they can argue anything. The likelihood of that happening is the likelihood of President Biden appointing me to the next vacancy of the Supreme Court. I mean, yeah, I guess it could happen, but you can bet anything you want to bet, and that ain't going to happen.
Final question.
Proceed.
If I may. Thank you.
Because I thought you were going to be the next appointment to the U.S. Supreme Court.
No. My final question, sir, is And I think this is somewhat related. Would each state be represented equally at the convention, or would there be some kind of, would each state be proportionally represented based on population?
States meet one state, one vote. You can send as many delegates as you want. Our recommendation is you send 5 or 7, an odd number, so that they would effectively, just as at the original convention, caucus together, and whoever had the majority within your delegation would cast Ohio's vote. And so, but it's one state, one vote, caucusing. There are dozens and dozens of state compacts, interstate compacts. And every interstate compact that I've looked at, and I've looked at everyone I know to look at, and every single one of them has the equality of the states as the means of voting. Some of them do it by giving the same number of delegates to each state, and the delegates can vote independently. Other states, they use the one state, one vote system in some kind of variation, but it's equality of the states is the absolute rule for every interstate compact in the country that I'm aware of. And so we would be following that. And there's the Interstate Commission for Uniform Laws that gave us the Uniform Commercial Code and many other things. It's one state, one vote. That's effectively exactly parallel to what would be happening here.
Thank you.
Representative Swearingen with a question.
Thank you, Mr. Chairman. Thank you very much for your testimony. My question was just, and Representative Brown kind of touched on this, the selection of what I understand to be one delegate from each state to the convention would be selected by the state legislature. I'm assuming that would be the House and the Senate. And could you maybe elaborate on what the process might look like? Would there be resumes submitted, vote, how would that occur? Thank you.
Mr. Chairman, Representative Swearingen. A state could, if you wanted to have one delegate, I would not suggest it. Your state gets one vote as a unit. And so you could, if you want to send 50, I wouldn't recommend it. It wouldn't be fiscally responsible and create a lot of problems, but I would recommend 5, 7, some number like that. And the House and the Senate would have to collaborate on the process. We have a set of model rules on how to do that. And the best framework for doing this is, we believe, rules, not legislation. The reason for that is that there have been multiple cases going to the Supreme Court on this point, and that is Article 5 power is held by the state legislature, not by the state government. The governor has no role in the process of Article 5. And so ordinary legislation, the governor signs it. This resolution that you're debating today, or considering today, does not go to the governor. It's this, and so legislative rules can control the process in a fashion that can't really be challenged. And so I would suggest that as we get close to the convention, as we get close to 34, we're at 19 right now and moving, that as soon as possible, but certainly by that time, adopt joint rules that clarify the process. We have models for you to consider. It's really pretty easy. I mean, a lot of states are doing things like the leadership of each house recommends 3 people, and then there's a process for getting the 7th. It's the kind of thing you do for creating commissions and joint study things on a pretty regular basis. It's not unusual.
Continue.
Just a quick follow-up. In your opinion, would you advise that the legislature put rules on those? Let's just say they went with 5 or 7 delegates to the convention. Should the legislature put rules on those individuals on how, almost like bylaws of how they're to conduct themselves or make decisions while they're at the convention? Or do you advise just leaving that open-ended?
Mr. Chairman, Representative Swearingen, the model rules we have, I would say, a moderate degree of control. For example, one of the things that we've suggested is that the group name one person as a spokesman for the state of Ohio, that you don't have all of them going off and spouting this and that and the other thing. You could adopt that. You don't have to adopt that. But that's the kind of thing you could adopt. And so you can, but I would not want to tie their hands so that they, every single little thing that they're doing, they have to come back here for direction or guidance. But I would put some big pieces in place, and we have some suggestions, but there could be others. The hearing process of adopting such rules would help clarify some ideas that I think would probably be for the better overall.
That's very helpful. Thank you.
Representative Skindell with the question.
Thank you, Mr. Chair. I want to return to the line of questioning that Representative Brown had, which is this provisions found at line 67 through 68 in the resolution dealing with one state, one vote. You claim that it's equality of the states is something commonly used in some compacts. I find this provision very troubling because equality does not necessarily mean that it's fair for the citizens. So Wyoming, for example, which has a population of 580,000 people, would have the same vote as state of Ohio, which has nearly 12 million people. So you're watering down the influence of the people of Ohio. They have less of a say-so by population. And I find that concept troubling and unfair for the citizens of Ohio.
Mr. Chairman, Representative Skindell, the exact same criticism can be leveled at the U.S. Senate because it is based on the equality of the states. And we represent, the House represents population. Population is an important component of our government, and one House is dedicated to that. Both houses in this chamber are dedicated to, or are divided on a very strict population equality basis. But it's not the only consideration. And it's one state, one vote on the ratification process. That can't be doubted. Wyoming has the exact same voting power as California on whether a constitutional amendment is ratified. It's just the structure of a federal constitutional republic. If we are a pure democracy, and that was the way the Constitution was written and the way the government was framed, and that was the only guiding star principle that we were to follow, then your critique would be well taken. But it's not the only principle, and we're not starting from scratch. We're not writing the process freshly. We're not deciding what should they have done. We're following the rules that they did create. And the rules they did create gave a role to the states. It takes 34 states to call the convention. That inequality that you talk about is bound up there. It takes 38 states to ratify. The equality that you criticize is bound up there. And it's the same thing at the convention. It's states at every level of the process. It's equality of the states that's inherent in the process at all three stages. And whatever equality in that is to the nature of a constitutional republic, just like the U.S. Senate.
Mr. Chair, follow-up. So you say it's in the structure and it's in the rules. The problem is this application is setting forth the rule. We are creating an unfair situation by requiring equality of the states that have been held to. And we don't have full equality of the states in the Congress because, again, as you mentioned, the House of Representatives is based upon population. So there's a consideration of both. This particular application does not consider both situations, and it leads to unfair situations for the people of Ohio.
Mr. Chairman, Representative Skindell, if, again, we were writing the process fresh, we could debate whether this was a good idea or a bad idea. We're not there. We can't debate whether the Electoral College should exist or not. We can try to change that. You can change the process for it, but that's the process we got. States matter in electing the president. There is equality built into it because every state legislature that controls every step of the process is based on equality of population within the state. So the voters of Canton don't have more influence than the voters of Toledo or Take any other two places you want. There's equality within the state that is guaranteed as the structure of the process. But if you want us to jettison the equality of the states, we've got a lot of things to jettison. We've got to get rid of the Electoral College. We've got to get rid of the U.S. Senate. We've got to get rid of the entire process of amending the Constitution of the United States, not just one element of it. And so if you think the process is unfair, then the thing for you to do is to call for a convention of the states to change Article 5 to require proportional representation at every stage of the process. There's a way to write that to do that. And if you can get 38 states to agree with you, more power to you. But until then, it's the structure that the founders gave us, and the wisdom of it is for history to decide.
Mr. Chair, follow up. So the structure of the convention is being dictated by us, not some 200 plus years ago by the founders of this country. We in this resolution are saying one state, one vote. We can change that. We can debate that now so that when amendments are proposed and there's discussion at the floor of the convention, there's fairness in the system, not equality of the states, which is unfair to the people of Ohio. My other concern about this equality of the states proposal is that the majority of the states have a lower population than Ohio, and they tend to be less diverse. The more populous states tend to be a little bit more diverse. So when you have this equality of the states based upon just the states, you're weighting it towards a white population and discounting the various minorities, the ethnic groups, and the racial groups within this country. And again, it's unfair. It's unfair to the citizens of Ohio.
Mr. Chairman, Representative Skandel, what is being done in this resolution is not creating law. Ohio cannot dictate the rule for the convention. Ohio can dictate to its delegates how they're going to vote. That's it. And so if 26 states come to the convention instructing their delegates to affirm the natural process, that is, it's one state, one vote, vote's over. Because that first vote is going to be taken one state, one vote, whether anybody likes it or not. That's how the first vote will be taken. And I'm certain that there will be an attempt to change that. I mean, California will make the motion, New York will second it. Interestingly, Texas and Florida, I can pretty well guarantee you, will vote against it, even though they're two of the very most populous states. And so the suggestion that you're creating anything is like this legislature citing a rule of common law as you're making a piece of legislation. You cite pre-existing rules on a regular basis, and this is no different. You're reciting the reality that that's how it is, and you're going to make sure that your delegates are not going to engage in some kind of rebellion that's going to just waste time and end up being defeated anyway.
Representative Thomas with the question.
Mr. Farris, thanks for being here today. Thanks for your testimony. My question is about Texas, and most U.S. citizens would like look at the situation in Texas and would like a solution to the standoff between the state and the federal government. How could a convention of states propose an amendment to fix this issue?
Mr. Chairman, Representative Thomas, well, there are two different paths. One is you could do a standalone application that would just address the border situation, and you could call a convention to say, we'd like a convention to solely address a remedy for the border crisis, and then you would have a convention on that topic. Under our application, since it makes germane things that reduce the power and jurisdiction of the federal government, an amendment that would give states joint jurisdiction to pass legislation to control the border within their state so that you wouldn't have automatic federal supremacy. You could give Texas the right to control Texas's border jointly with the federal government. You could give, and if the feds didn't want to enforce their law, okay, that's fine. Texas can enforce its law. And so that would be germane under our application. So at least to that extent, it would be appropriate. You could also, under our application, if you wanted to say the United States does not have the authority to give asylum to people who came here illegally, an amendment could be crafted for that purpose. That would be germane. Do I think that that is likely to get out of the convention and get ratified by 38 states? Not very likely, but it's just an example of what could happen. Although I think the first example I gave you could get out and could get ratified, where you give joint jurisdiction to the border states so that they can control their borders.
Representative Swearingen with a question.
Yeah, thank you, Mr. Chairman. Vice Chairman Thomas just hit on my question, because not only is our spending just wildly out of control at the federal level, we have a wide open border too. So thank you for speaking on that. My question was going to be, what can we do about the border at the Convention of the States? And I think you just answered that very nicely.
Thank you.
Thank you for your testimony. I have one quick question. And first, I've heard hours and hours of testimony on this issue in the past, and probably have heard you testify in front of me at various times. But functional anarchist is a new term. I appreciate that. I've been thinking about that all the way through your testimony, thinking about the people I know and friends of mine who are now functional anarchists. So I'll have fun telling them that. And not sure whether it's a compliment or picking on it, but my question is, so 38 states need to approve this exactly in the exact form on all three of these issues, correct? And right now 19 have, but it has to be exact. The resolution has to be exactly the same in all 38 states. Is that correct?
Almost, Mr. Chairman. The application phase, it's 34 states have to agree on the topics. And probably you could get away with minor variations on the topic. We're not taking any chances. Every state that has done this has done it verbatim on the operative language, not on the whereases and all the surrounding. But the operative resolution has been precisely this. Frankly, I got into this by going to a meeting in Denver 12 years ago, we'll call it, where we're looking at the BBA, Balanced Budget Amendment applications. And I looked at all the various forms of it, and I go, you guys we'll have a real aggregation problem, because they've been written in so many different ways. And, you know, many of them, for example, say, we want to hold a convention to call for this particular amendment. Well, that doesn't aggregate with anything other than calls for that particular amendment. The best way to do it is just say, let's have a convention on balanced budget amendment. But only like 6 states have ever done that. So I spoke up at the meeting and says, why don't we just start over and do it right? And that's where the Convention of States process was born, was on my suggestion, let's start over and do it right. And as long as we're fixing it, let's fix it. Because if you just try say balance the budget, it doesn't say you're going to control the spending necessarily, because the mechanisms to do that may or may not be present in a balanced budget amendment. But controlling the spending is the game. And the real game there is to get them to go back to spending for the enumerated powers. If you're spending on things that are outside the enumerated powers of the federal government, we're always going to be in this crazy broke situation where we're trying to fund everything for everybody. It's unsustainable, and our country shouldn't have to put up with it anymore.
So one quick follow-up.
Yeah.
So if, we trying to pass something through the legislature, right. I expect there's several different beliefs amongst probably even this committee, but certainly the legislature as a whole on those 3 topics. Some of us may strongly support 2 of them. Some may support all 3. Some may support 1. If we as an Ohio legislature were to craft one that said, we agree with 2 out of these 3, and other states agreed with 2 out of the 3, can we just do, would that count towards doing 2 out of the 3, or does it, or would you have to start over with everybody just doing 2 items?
Mr. Chairman, the best answer I give you is we throw dust in the air when we don't need to. And so it creates uncertainty. We'd have to litigate that, frankly. And I don't want to have to litigate. I mean, people can file a lawsuit that's just nuts. I want to eliminate reasonable litigation. And so I would make an observation and a suggestion. The observation is, we're agreeing on an agenda, not on an outcome. And so, I mean, I'll tell you from testifying in, I don't know how many state legislatures now, lots. One of the most popular ideas in our application among people is term limits. The least popular idea among legislators is term limits. And so, there you go. Now, who's going to ratify this at the end of the day? Legislatures are going to ratify it. And so if a term limits proposal gets 26 states to vote for it by delegates appointed by the legislatures, it's going to go out, and then the legislatures are going to get 38 states to vote yes. My guess is that's going to be a big uphill battle. And so whether that one happens or not, I don't know. Now, my suggestion would be, what you could do, and what I would ask you to do if you're considering something like this, is to pass it verbatim and then instruct the Ohio delegates to not vote in favor of any term limits proposal. Other states have done that exact thing. And so you're keeping the resolution so that there's no aggregation problem, but you're bending the course of the discussion in a particular direction that, if that's your concern, you can bend the course in that way.
Representative Humphries with a question.
All right. Thank you, Mr. Chairman. And again, thank you for hanging in there. Lots of questions today. I'm going to be brief. My question is, and I think you touched on it, but I'm going to ask it again. We're talking about topics discussed at the convention. And my question is, I know that there might be like a wide variation, but what are some of the topics that would be discussed at a convention by the delegates? Because we know the language is sort of vague. So just real quick, just wanted to know.
I'll give you 4 examples of things that I think can have political, realistic ideas behind them, and they're not crazy. One would be a single subject rule on Congress, to say that they get rid of these multi-thousand pages of omnibus bills that throw everything in the kitchen sink in them. No, one single subject. 41 states have a single subject rule. Congress should have a single subject rule. I think that has legs and could get ratified by 38 states. The treaty idea that I said earlier, that all treaties have to be ratified by the Senate, I think that has value and could get ratified by 38 states. I think that limiting the power of the federal government vis-a-vis the Department of Education is going to be a closer call, but I think that you probably could box the federal government out of the education business, not counting military education, not counting the District of Columbia, but vis-a-vis the states, you could box the federal government out of education, and that has a better chance of being ratified, other than some of the other topics. I would like to fix the Commerce Clause and the General Welfare Clause to go back to the original meanings of both, which is, if the states can regulate it, the federal government can't. If the states can spend money on it, the federal government can't. That's the original meaning of both of those clauses. And 99% of the way the federal government has gone awry is violation of those 2 clauses. And so that's my ideal, but getting those ratified, that's a tougher chore. And so, but those are some examples of things I think are realistic.
Representative Brown with a question.
Thank you, Chair. In Ohio, our Constitution does provide for a single subject rule, which we ignore all the time. We just did ignore it not too long ago, which I pointed out on the floor of the House. I pointed out many, many times. So I don't think the notion that we can have a single subject rule is really going to provide any real guardrail at all, because we have it here and we ignore it with impunity.
Mr.
I
Chairman,
think
may
that was a
respond?
statement, not a question, but you're welcome to respond.
With impunity?
Mr. Chairman, Representative Brown, let me write it and I'll fix that problem. Because the easiest way is I would write into it taxpayer standing to challenge any litigation, because the biggest problem with violations of those is who has standing to challenge the violation of the rule. If you put right in a rule that says any taxpayer of Ohio has standing to challenge the violation of the single subject rule, all of a sudden you got a real rule. And you could do that at the federal level as well. And there might be other things that we could do. We need to study that, why this has been abused in some states. And you're not the only state that said that. But I think you could write it correctly, because it is a good rule. And your frustration tells me you agree with the idea that it is a good rule. It should be used. And so you and I work together. We'll get it written correctly.
Thank you for your testimony. I appreciate you being
Mr. Chairman.
with.
Hey, thanks for watching that with me, but that's not the end. You want to keep watching because after Mike Farris sits down, the committee hears public testimony from the COS Ohio team. And it really is a masterclass for citizens like you and me on how to testify for COS in front of legislators. So whether you've done it before and you just want to get better, or you've never done it and you'd like to know how it's done, keep watching. And if you want to give our efforts to help support citizen volunteers with the resources and training they need, then click on the link below and make a donation to Convention of States.
Chairman Peterson, Vice Chair Thomas, Ranking Member Humphrey, and members of the committee. As I said, my name is Bill Scott. I'm from Dayton, Ohio, and House District 38. I serve as the State Director for Convention of States here in Ohio. We're a nationwide organization, nonprofit with over 5 million supporters, and more than 2.5 million Americans have signed our petition for the Convention of States. Right here in Ohio, we have 113,000 of those who have signed the petition. Today, I'd like to talk a little bit about the purpose of the Article 5 Convention and why it's in the Constitution. The founders established 3 branches of the federal government with checks and balances to limit powers of each branch. They also check powers by wisely balancing it between federal and state governments. That balance of power is called federalism. And unfortunately, that balancing check is now nearly gone in our country. And why is that? Because for many decades, the states have failed to push back against the federal overreach by asserting their own constitutional powers over centralized federal power grabs. As the power in DC has grown, America's trust in federal government has declined. According to a 2022 research article by Pew, in the 1960s, more than 70% of Americans trusted their federal government to do the right thing just about always, maybe not always, but they trusted it most of the time. Today, that's only 20% of Americans think the federal government can be trusted. This finding holds for both Democrats, Republicans, as Americans have become more and more dissatisfied with an extremely bloated and overreaching federal government. As Dr. Farris mentioned pretty well here, Article 5 of the Constitution was designed to ensure that that balance of power between federal and state governments remains in place. And with Article 5, the states can rebalance those powers using their ability to propose amendments. With the states proposing amendments to the Constitution, it's important to recognize the distinction between the Constitutional Convention of 1787 and what's being proposed here today in HJR 3, which is simply a meeting of countrywide state legislators to propose limited amendments. The Constitutional Convention of 1787 was obviously not called under Article 5 of the Constitution because it didn't exist yet. It wasn't written. Opponents of convention states often try to confuse and scare people by conflating 2 different types of meetings. An amendment proposing conventions is not a constitutional convention, or a con-con, as many opponents call it, in a rather pejorative way, I might say. The Constitutional Convention of 1787 was not called under the Articles because the Articles made no provision for any such convention. Instead, it was called under the reserved sovereign authority of the states. The states were completely sovereign at the time our Constitution was adopted, and the Articles of Confederation recognized that they had the power to write a new Constitution. They had that power to draft a new system of government, and that's what they did in the Constitutional Convention of 1787. That's not what HJR 3 does. What this resolution does is use Article 5 of the Constitution to allow the states to exercise the same power that Congress has every day to propose amendments. No different. They can propose amendments any day of the week, and they do. In just 20 words, that's what Clause 2 is all about. It says, and I won't read it again because Representative Brown has already read it. So as of now, 19 states have passed virtually identical and operative language in Ohio in HJR 3. If it's passed, along with a companion resolution in the Senate, we could become the 20th, 21st, 22nd state. Our United States Constitution is the world's longest surviving written charter of government. The unrestrained growth of reckless spending by our federal government places our country in an extremely dangerous position. If we don't put a stop to the financial recklessness of DC Inescapable monetary forces will do it for us, throwing the economy and our way of life into chaos. The worldwide consequences would be, I dare say, devastating if America collapses due to its own self-inflicted wounds. As legislators in Ohio, you have the authority and the responsibility to check the federal government, and each of you took an oath of office to defend and support the Constitution. So your support today in HJR 3 can help fulfill that promise.
Chairman Peterson, Vice Chair Thomas, and Ranking Member Humphrey, and members of the committee. My name is Brenda Mitchell, and I'm from Bellefontaine, Ohio, and I live in House District 85. Our system of electing members of Congress was intended by the founders to operate like a free market system, in the sense that legislators who served the people well could be reelected, while those who performed poorly would be voted out. The founders never intended legislators to make a career of Congress and to serve for 30 or 40 years, such as Chuck Schumer, Mitch McConnell, Nancy Pelosi, and Chuck Grassley. As proof, throughout the 1800s, the norm was for members of Congress to serve just 1 or 2 terms. From 1850 to 1898, turnover in Congress averaged 50.2%, meaning half of Congress was replaced every election cycle. Today, 9 out of every 10 members of Congress who run for re-election win. This might be reasonable if Congress were popular with the American people, but it's not. Congress's approval rating is about 15%. Clearly, our system is broken. And why is our system broken? Why can't the American people get the highly unpopular members of Congress replaced with new people bringing new ideas and to address our country's problems? The answer, in large part, is that incumbents have unfair advantages that bias elections in their favor. These advantages include incumbents have a 4-to-1 fundraising advantage over challengers. In many cases, the advantage is much higher. Incumbents can leverage political patronage, meaning politicians doing favors for constituents in exchange for votes. Party support usually favors incumbents, and incumbents usually have better established campaign infrastructure and staff compared to the challengers. Media attention usually favors incumbents, and access to government services, such as the ability to hold official events or town hall meetings, favors incumbents. Saying it simply, the deck is stacked in favor of incumbents. This is, for the most part, how Congress can have just a 15% approval rating and yet have a 90% reelection rate. The problems that have plagued our country for decades never seem to get fixed because the politicians who have either created them or have perpetuated them continue to stay in office. Problems like our national debt, immigration policy, our healthcare affordability, public school lackluster results, and the list goes on. One of the solutions to the problems is to place term limits on Congress. The 22nd Amendment to the Constitution places term limits on the presidency of the United States. It's now time for another amendment that limits the period of service for the U.S. Congress. Term limits for Congress would infuse the House and Senate with a regular influx of new people from the states with fresh ideas and solutions to our nation's biggest problems. It would decrease the concentration of power in Washington, D.C. by giving more citizens the chance to serve in Congress. It would help members of Congress to take their jobs more seriously, since they will be required to return home and live with the laws that they helped to pass or live with the problems they failed to solve while in Congress. It would also reduce the influence of special interest groups and lobbyists on politicians. I can imagine, as you're all sitting here, that there are members of the Ohio legislature who might aspire to serve in the U.S. Congress. A term limits amendment would only increase the opportunities to serve in Congress with more turnover in Washington, D.C. Some have expressed concern that term limits on Congress could backfire if the period of service is too short. This concern was reflected in the results of an Article 5 convention simulation that occurred last summer with actual state legislators. In that simulated convention, the proposed maximum length of service was set at 24 years. I think most would agree that 24 years of service in Congress is more than enough time to make meaningful contributions to our country. In closing, our country faces significant problems, and sending the same politicians back to Washington, D.C. every election cycle is not working. Placing term limits on Congress through an amendment to the Constitution will help improve that situation. Term limits on Congress is very popular with the American people. A recent poll found that 80% of Americans support it. Term limits would increase the opportunity for more Ohioans to serve in Congress, including members from the Ohio legislature. For these reasons, please support passage of HJR 3.
Chairman Peterson, Vice Chair Thomas, Ranking Member Humphrey, and members of the committee. My name is Chad Gump, and I'm from House District 49 in North Canton, Ohio. Today, my remarks are to refute two of the common claims that are made by some people that do oppose a convention of states, and appreciate everyone's time here today, and I've been asked to try to get the things out of there that we've already discussed. I'll do the best I can on that, okay? The first claim that you might not have thought about is that somebody said, well, there's absolutely no rules in the Constitution for how to run an Article 5 convention. So it's a good question, and then the question becomes, well, it could go anywhere without any rules. So reverting back to that Professor Nadelson that you heard him talk about a little bit earlier, he explains to the Marquette Law Review in an article from 2020, and I want to say it exactly the way he said it, so I'll try to keep it moving, okay? He said, competent constitutional scholars do not assume a phrase has no meaning merely because the Constitution and the framers' records do not define it. The usual reason for the lack of definition is the term is so well known and understood that there's no need to explain it. Things like illustrated phrases like original jurisdiction or trial by jury, those weren't originally explained out well either, but they were well known. So really, for that reason, the founders didn't really put a lot of time into wasting space, but taking space out of the Constitution. The other thing that I found very interesting is that there were 11 multi-state constitutions already in process or completed just after the signing of the declarations. And so we already had a background on what the rules would be. And some of those we already talked about. I'm going to hit on it real quick. We already talked about the state legislators are going to select who's going to be involved in it. We kind of talked about that a little bit. We talked about the voting. And I do want to click on one thing at the end was if the majority of states did not endorse a particular solution, it just wasn't adopted. It wasn't proposed. So if, kind of maybe explains itself, but I wanted you to know that. So there really isn't any claim that there are no rules for an Article 5 convention. Another claim would be the fact that since Congress calls the convention, well, why don't they just take it over and run it in the ground or do whatever they want? But he explained also in that it had been very clearly through multi-state conventions seen before that they could determine the time and the place and the purpose, but that's as far as they could go. So that was what they were. That's what their responsibility was. And he further clarifies that the overriding purpose of the state application and convention procedure is to bypass Congress. So if Congress could structure the convention, this would largely defeat the overriding purpose, which makes sense. Originally, if Congress were to dictate the state legislators how to select commissioners, then the Congress would be invading the incidental authority of the states as well. So it's kind of shown that time, place, and subject matter is their place in it. So without that, there really isn't a claim that they would override the power of a convention.
And my testimony is really motivated by the hope that my My children, my family, and your families and all Ohioans will continue to reap the benefits of the great country that we have here. I urge your support of HJR 3 because it is apparent that our federal government lacks fiscal discipline leading to unfathomable debt. It has expanded in scope well beyond the constitutional limits, leading to excessive regulation of states and their citizens, and it enables career politicians and bureaucrats. These problems stem primarily from certain sections of the Constitution and will not be solved by electing other well-meaning people to Congress. There's thus a need for reform, and to determine what reform is needed requires a conversation. Congress could initiate a conversation on these topics and suggest amendments to the Constitution. It has not done so, and it is highly unlikely that it will do so. As an institution, Congress will never acknowledge its shortcomings or overreach, much less voluntarily limit its own power or cede control over the states to their citizens. The drafters of the Constitution anticipated this eventuality and included Article 5 to permit state legislatures to begin a conversation among the states on how to remedy problems with federal governance. As has already been discussed, each of you took an oath under the U.S. Constitution. The U.S. Constitution requires state legislatures to have very few responsibilities under the U.S. Constitution for state legislatures. Aside from managing elections, perhaps the most important responsibility for state legislatures is to call a convention of states under Article 5 to discuss constitutional flaws. It's your duty to start the conversation. And as you conduct these hearings on this resolution, you can expect a lot of fearmongers, hand-wringers, knee-knockers, and bedwetters to warn that the sky will fall and life as we know it will cease if the Convention of States is called. Tell you do not believe them. Conventions among states, though not currently common, have a rich history in the United States. The law of Article 5 has been thoroughly researched by Professor Robert Nadelson, as we've heard, and you heard from one of the preeminent researchers on this topic, Michael Farris, today. It's well understood what Article 5 lays out. The biggest risk that you can let happen is that Congress will continue to lead us toward economic Armageddon and federal tyranny. Congress will not fix itself. So I ask you to have the courage to do that which only you as state legislators can do. Support HJR 3 so that Ohio may join other states in calling a convention of states. Please do your duty and begin the conversation.
Washington is broken, yet clearly has no plans to address our nation's problems with permanent solutions. We look to our country's bylaws for answers, our Constitution. The state amended convention under the authority of Article 5 of the Constitution offers a safe, civil, and effective response to the country's dire situation. Please be sure to carefully consider the words of HJR 3. It is straightforward, only 4 pages. Simply put, it is an application to Congress for a state amending convention. No more, no less. This is all we are asking you to support. We ask you not to be distracted by a few objectors. The passage of HJR 3 is far too important to allow its meaning to be overshadowed by doomsday predictions designed to impart fear in the hearts of Americans. Our opponents even resort to ad hominem attacks to discredit the reputations of convention of state leaderships, as well as the reputation of our founders for hypothetically allowing a runaway convention. If legislators had to contend with such apocalyptic disinformation every time they considered legislation, they would be petrified by fear and accomplish nothing. Your focus must remain on the words of our resolution and not the fear-driven propaganda perpetuated for decades by opponents of Article 5. If our opponents cannot even get their nihilistic claims published in a reputable legal journal, reviewed by constitutional experts, then you should not take them seriously. To alleviate the worry of a runaway claim, consider the U.S. Congress is now a permanent Article 5 convention. Article 5 authorizes Congress to propose amendments to the Constitution on any subject any day of the week. So it's hard to imagine a state convention could be more irresponsible than Congress. Yet there are no dangerous near misses and crazy amendments coming out of Congress. Why not? Congress is constrained by the political realities of ratification. 38 states must pass any proposed amendment. Since 1789, in fact, Congress has proposed more than 11,000 amendments to the Constitution. Of these, only 33 have been sent to the states for ratification, and only 27 have been ratified, the ones that were largely supported by the people. Proponents of Article 5, like me, have become disenchanted with the notion of just electing the right people next time or hoping state nullification will ever make any real difference. Unlike the opponents who tout softball antidotes to our country's problems, convention advocates seek to play a strong offense in the fight for American prosperity. Regardless of political party, the results of a state amending convention can be beneficial for you and me. A reduction in federal spending will allow us to keep a lot more of our money. We can curtail the growth of the national debt, which is now on the backs of our posterity. Without real action, even social safety nets that provide critical support during financial hardship will eventually be unsustainable. An amending convention of states is a safety feature packed into our Constitution by our founders for this moment in history. It is unethical for the states to deny their constitutional authority while Washington spends our country into oblivion. You raised your right hand to uphold the Constitution of the United States. This includes an Article 5 convention of the states, which exist as part of that Constitution. Therefore, it is the duty of state legislatures to utilize this tool, not deny it. Our country still rests under the good protection of our founders' wisdom. Please believe in all the objective reasons this convention will be successful, not in the loose speculation that purports that it will not be. There were people who opposed the founders and the Declaration of Independence from Britain. The founders forged ahead anyway. There were people who opposed the abolition of slavery. Lincoln did it anyway. There were people who opposed JFK and his challenge to place a man on the moon. He issued the challenge anyway. Albert Einstein once said, "The world is a dangerous place, not because of those who do evil, but because of those who look on and do nothing." We hope you will support moving HJR 3 forward to the House floor for a full vote.
Vice Chair Thomas, Ranking Member Humphrey, members of the committee. My name is Ed Mulholland. I'm from Zanesville, Ohio, House District 97. I'm a volunteer with Convention of States Action, and we seek your support of HJR 3 to address runaway overreach of the federal government. The Declaration of Independence was an announcement to the world that the colonists could and would manage their own affairs. It was a statement establishing the right of individual liberty and local sovereignty. The Constitution followed, securing the liberty of the people while granting the federal government only 27 enumerated powers. Later, the Bill of Rights the 10th Amendment reinforced the limits on federal power. James Madison, an author of the Constitution and fourth President of the United States, put it this way: the powers delegated by the Constitution to the federal government are few and defined. Those of state governments are numerous and indefinite. By dividing power between the federal and state governments, the framers built a safeguard into our political system to restrain federal overreach. This division of power is called federalism, and sadly, it's been dying a slow death for decades. The death of federalism has led to a concentration of power at the federal level. As the power of the federal government expands, so expands the necessary regulation and control that steals the very liberties the government is supposed to protect. Why is federalism on its deathbed? Prior to the New Deal era, local economic activities such as labor, manufacturing, agriculture, mining were widely understood to be under the purview of state governments. They were not considered part of interstate commerce. Then, Supreme Court decisions like upholding the National Labor Relations Act in 1937 and Wickard v. Filburn in 1942 dramatically changed the interpretation of the Constitution's Commerce Clause, enlarging the federal government's lawmaking authority at the expense of state sovereignty. With its new expanded authority, the government grew so much, Congress was forced to defer a great deal of authority to newly created agencies, and today the number of statutes passed by our elected representatives in Congress is dwarfed by the number of regulations created by federal agencies staffed by unelected bureaucrats. The Supreme Court's arbitrary reinterpretation of the Commerce Clause can be corrected with an amendment to the Constitution. Doing so will rightly shift power out of Washington, D.C. and back to the states where it belongs and where our country's founders intended it to be. This will help revive federalism and the balanced power between federal and state governments. Another contributor to the death of federalism was the United States v. Butler decision, heard about a little bit earlier, which reinterpreted the General Welfare Clause. Prior to this ruling, the General Welfare Clause was interpreted to mean that Congress could only spend money in service of its 27 enumerated powers. It could not spend money on activities states could spend money on. For example, states can spend money on education, welfare, medical, and retirement programs. Accordingly, Congress had no jurisdiction for such programs. However, after this Supreme Court ruling, the floodgates were opened and Congress was permitted to spend money on essentially anything it wanted. This Supreme Court reinterpretation of General Welfare Clause can also be corrected through an amendment to the Constitution that clarifies the clause according to the framers' intentions. Pandora's box of federal government expansion can, in fact, be closed with such an amendment. Now, some of you might be wondering, what would happen to federal programs Americans have come to rely upon, like Social Security? Those programs don't have to end. Their administration could shift from federal government to state governments. The programs could be more closely tailored to the particular needs of each state. As our elected officials, you would be in control. And we all know states tend to be more efficient with their resources and more responsive to their citizens' needs. In summary, federalism is all but dead in our country due to an ever-expanding federal government that treats states as federal agencies. This is a dangerous slide toward the concentration of absolute power at the federal level, concentrated power that always leads to tyranny and loss of individual liberty. This imbalance of power is a result of Supreme Court decisions that reinterpreted the Constitution, taking power from states and giving it to the federal government. To preserve state sovereignty and the liberties of the people, we must restore federalism. HCR 3 calls for a convention to give states the opportunity to at least discuss this important issue.
Since there's been some lively discussion on we as Ohioans, I will throw in that I'm a graduate of Ohio High School. I'm also a double graduate of Ohio Public University. So I've been around a while. I'm going to skip through a few things here, so if you're following along on your iPads, I may skip a few paragraphs. But today, I was going to discuss an opposition statement that we often get about amending the Constitution will provide no benefit because the federal government does not follow the Constitution now anyway. Well, I can appreciate the federal government doesn't follow the Constitution now, and I know I've expressed that sentiment myself on several occasions. While I am not a constitutional attorney nor a constitutional scholar, I've learned that to comprehend the subject, one must first recognize that the federal government is not required to follow the original Constitution as written by our founders. Rather, it's required to follow the Constitution as interpreted by the Supreme Court of the United States. That's a major difference. The improper accumulation of power by the federal government and the departure from the following Constitution as originated by our framers has risen in a sense from the Constitution itself. The Constitution permits the federal judiciary to be the final arbiter, interpreter of the Constitution. Because the framers did not have a great deal of experience in the practice of judicial review, they did not assign adequate checks and balances on the judiciary's branch of government, did not foresee how the Supreme Court would legislate from the bench. So once you understand this, it becomes clear how the federal government can justify some of its actions. The Constitution as interpreted by the Supreme Court today is the problem. This interpretation allows the federal government to engage in undeclared wars, provide government agencies with the capability to spy on us, the US citizens, you, massive federal debt and devaluation of our currency. I think we've all lived through a lot of that in the last 2 years. Executive agreements with foreign powers without Senate ratification, which is a direct violation of the US Constitution. and the deregulation of rulemaking to unelected bureaucrats. We've had that discussion on many topics by my compatriots here today. I'm going to skip the next 3 or 4 paragraphs and go to the summary, because again, you have a cushion and I don't, and I'm getting a little tired. So in conclusion, the claim that many of the Constitution provide no benefit because the federal government doesn't abide with the Constitution anyway is a bit misleading, because it naively overlooks the fact that it's not the original Constitution. It's the one approved, authorized, and promoted by the Supreme Court. Through changes to the existing Constitution using an Article 5 convention, we can resolve most of this, or at least improve our lot in life and where we are with everything that we live and do. So it could return us to a separation of powers that's more acceptable. It could return us to closer to the federalism that our country was originally founded on. And I would add, in doing this research and talking to many people, I probably knocked on 500 doors last year. Republicans, Democrats, non-committed. And at least 80% of those doors I knocked on approved of the 3 principles we're presenting to you today, Article 5. And we had many lively conversations about all the things that are going on. And I heard some of those exact feelings expressed from those folks out in the field too, on both sides of the aisle. So we need to do something. We need to move forward as a country. And we do have a huge divide in front of us. And a person mentioned that today. Let's try to build a bridge across that divide. Let's use the Article 5 process to get that done, to make progress, to push this forward. Because if we continue to ignore the ability that we're given in the Constitution to make that attempt, we're not going to go any further than we are today.
Start by saying that I'm sure that Representative Brown and I will disagree a lot.
The chair disagrees with him on occasion also.
As legislators, I'm sure, though, that you have felt the heavy hand of the federal government as it has repeatedly usurped the rights of the state. Maybe even Representative Brown, you've felt that. The federal government has most assuredly forgotten that it derives its power from the states, but only because the states have forgotten that it is their job to keep a check on the federal government. When the federal government steps outside their constitutional box, no letter writing campaign, no demonstration, not even an election is going to put them back into their place. Only the state legislators have the power to control them through constitutional amendments. Today, Washington is like an unruly teenager with absentee parents, access to the refrigerator, keys to the car, and living in a nice warm home. No parents. Well, according to our Constitution, you are those parents. Please show up. I'm standing here before you asking you to be the great statesmen and stateswomen that we need right now, that we needed years ago. I cannot fix Washington, but you can. An Article 5 Convention of States is for you to enact. It is your responsibility. Indeed, it is your obligation. You find yourself here on this committee in this moment to make history. Lay aside ego, lay aside personal ambitions, lay aside political affiliations. Be great for us.
Thank you for granting me the opportunity to speak on a subject that is very close to my heart. The Convention of States effort, particularly through the lens of entrepreneurship and personal freedom. My name is Mark Paquita, and I am a successful entrepreneur from Dublin, Ohio, House District 11, who for over 20 years grew a business from scratch into about $100 million annual revenue enterprise, doing business in over 30 states and employing almost 800 employees, associates at sale, generating more than 3,500 jobs over those years. I know of what I speak. In the next few minutes, I aim to shed light on why this movement is not just a political endeavor, but a beacon of hope for fostering innovation, economic growth, and the safeguarding of our liberties. The Convention of States project seeks to invoke Article 5 of the United States Constitution, allowing a Convention of States to propose amendments to the Constitution. The initiative is born from a desire to address and curtail overreach of federal powers, restoring the balance of government and governance as originally intended by our founding fathers. But how does this relate to entrepreneurship and personal freedom? The connection is both profound and pivotal. At the heart of entrepreneurship is the spirit of innovation and the freedom to pursue one's vision. Entrepreneurs are the backbone of the American economy, driving growth, creating jobs, and pushing the boundaries of innovation. However, the overextension of federal regulations often creates a stifling environment for these pioneers. The complexity and breadth of federal laws can hamper small businesses and startups, which lack the resources of larger corporations to navigate these waters. By advocating for a convention of states, we seek to streamline governance, reduce unnecessary regulatory burdens, and foster an environment where entrepreneurship can flourish. Personal freedom is the cornerstone of American identity. It is the very principle that has attracted generations of immigrants to our shores, seeking the liberty to shape their destinies. Yet this foundational value is under threat when the federal government grows too large and too intrusive, as our federal government surely has. The Convention of States effort aims to reinforce the rights of individuals and states, ensuring that personal freedoms are not eroded by distant bureaucracies. In doing so, it not only protects the liberty of today's citizens, but also safeguards those rights for future generations. By decentralizing power, the Convention of States would empower local and state governments to be the primary architects of policies affecting their citizens. This is particularly beneficial for entrepreneurship, as it allows for a more tailored, responsive, and efficient government. Localized decision-making better understands the unique challenges and opportunities within each community, enabling policies that are conducive to business growth and innovation. In conclusion, the Convention of States effort is not merely a political maneuver, it is a clarion call for the revival of the American dream. It seeks to create a fertile ground for entrepreneurs to thrive, unencumbered by excessive regulation, and to guarantee that the personal freedoms our forebears fought for remain intact. By supporting this cause, we champion a future where innovation, prosperity, and freedom are the hallmarks of our nation. Thank you for your time, and I urge you to consider the profound positive impact the Convention of States will have on entrepreneurship and personal freedom in America. I recommend you pass Ohio House Joint Resolution 3 from committee for deliberation by the entire body of the Ohio.
My name is Patrick Cloten. I'm from Lyons, Ohio, and am represented in the Ohio House by Representative Scott Olslager. I've been a political activist for well over 30 years, helping in various campaigns for offices at the federal, state, and local level. First, I want to thank you for this hearing. And most of all, I want to thank you for being public officials. Yours is not an easy job. It takes a lot of courage to be out on that street campaign. So thanks, all of you. Today, I'm asking for your support of Article 5, a call for a limited convention proposing amendments to the United States Constitution to rectify injuries to our liberties. There will be much testimony on this subject, but I think the essential issue before us is being overlooked. Are we capable of self-governance? Do we still believe in representative government? Are we not concerned about the consolidated powers of the federal government? Consider that 250 years ago, our founding fathers fought King George, the English Parliament, and the most powerful military in the world. Many of their fellow citizens thought it was madness to oppose the dictates of an oppressive authoritarian government. Lucky for us, they did not heed the worries of the timid, but chose to fight the right for self-governance through the consent of the governed. The result was a freedom-loving people, confident in their ability to run their own lives and wise enough to be wary of consolidated power. Unfortunately, today we have a tyrannical federal bureaucracy that has its intent the destruction of these liberties by consolidating the powers of the legislative, executive, and judicial branches of government, destroying the concept of separation of powers. This principle of separation of powers and the consent of govern are essential concepts to ensuring our freedoms. Consider first, federal agencies write the rules, which is a legislative function. Secondly, federal agencies enforce these rules. This is an executive function. Thirdly, if you disagree with these agencies, they will drag you into their administrative court. They will tell you why you're wrong, potentially fine you and/or throw you in jail, which is a judicial function. Think about what this might do to one of our farmers or small businessmen, owners who might run afoul of their incomprehensible rules. They will be adjudicated in their administrative courts and be judged without the right to a trial by their peers. King George and the British Parliament could only have wished to have these powers over our citizens. This brings me to my main point. Do we have the capacity for self-governance and enough concern for this concentration of powers? Are we so timid and worried that we'd rather give up our liberties to a corrupt, tyrannical Washington bureaucracy? Are we willing to strive to uphold the American dream of self-rule and secure these liberties? I'm sure you've all heard of Elizabeth Paul when at the Constitutional Convention, she seen Mr. Franklin walk by, and she says to Mr. Franklin, "What kind of government have you given us, Mr. Franklin?" Mr. Franklin replied, "A republic if you can keep it." This is the question before us. Do we continue this process of creating a more perfect union? Article 5 is called for a convention of states to propose amendments to resolve and help the consent of the governed.
Chairman Peterson, Vice Chairman Thomas, and Ranking Member Humphrey, members of the committee, I am Paul Sisk. I come from Hamilton Township, Warren County, Ohio, District 55. I want to begin with a quote. If you're reading, it's not in my material. I think you need something fresh. It appears that I could not do your job sitting all day listening, and how you do it, I want to commend you. I don't know how you can absorb it all and hold it all in. I think your posterior is probably speaking to you.
We have padded seats. You and the audience do not, so sorry about that.
A nice luxury. Bland Blanchard said, whenever you're making a presentation, state the issue simply, handle objections fairly, drive a strong conclusion. Most of the things that are in my testimony have been covered, so I'm not going to spend time reading it to you. I know you say thank you very much, but I do want to convey to you, as you should see from these people who have given up their days of work, as have I taken a day off of work, and the hours that have been spent in preparation and rehearsal for this day. To me, this is not about labels. This is about patriotism and country and doing the right thing. This is why my vote counts, and this is why I'm here today. My specific remarks are intended to dispel the claim that a Article 5 Convention of States would create a runaway convention. And things from that would result in a loss of Bill of Rights or, in fact, our entire Constitution. And of course, you've already heard comments about that. My sources are the same, Dr. Farris, Dr. Nicholson. An Article 5 convention for amending the Constitution is just simply about 50 states getting together, convening a meeting, and talking about ways that we can make America better. Amendments. This is how we're supposed to do it. Multi-state meetings and conventions have been going on for years. In fact, more than 350 years. And in the 40 multi-state conventions that we have on record in America, none have resulted in a runaway convention. Not one, not even a hint of one. Zero. In the case of Article 5 conventions, there are 9 safeguards to ensure that we are meeting the intentions of the framers of the Constitution. I'm just going to hit them briefly. First order of business is to elect the right leaders. It's up to you. That's why we elected you. You choose the leaders. We're counting on you. Do the best you can. You choose how it works. We're counting on you. Safeguard number 2. Opposition claims that delegates will have plenipotentiary, that is, unlimited power of the convention, and that's not true. They only have the power that you give them. If you give them the power, then you are responsible for what they're going to do. So the onus is on you. Number 3. Well, let me go back to it because I think this is important to state. This HRJ 3 states that a convention of states for proposing amendments to the Constitution of the United States convened pursuant to this application shall be limited to consideration of the topics herein specified and no other. So whatever you choose, right, your delegates are going to only be able to talk about that thing. All right, and my safeguard number 3 is there's no provision in the Constitution for replacing the Constitution. It's ridiculous. Number 4, in order for an amendment to become officially proposed at a convention, 26 states have to vote for it. And since 34 plus states will have requested the convention, then there's no way an amendment for rescinding any component, for example, of the Bill of Rights. That could not happen. 26 states getting together, you know there's no way that that could happen. The 34 plus states that requested the convention would never vote for it. Number 5, if by some means an amendment was proposed that fell outside of the scope of the convention and what your delegates are supposed to be doing, Congress would be obligated to select a mode of ratification, and then the process would stop. It would kill any invalid proposal. Number 6, the Constitution stipulates that after an amendment is officially proposed at an Article 5 convention, it only becomes the part of the Constitution if it's ratified by 38 states. We've already heard this argument. Number 7, if a delegate were to violate their duty or their instructions, they can be recalled. And in HJR 3, it states the Ohio General Assembly may provide further instructions to its delegates and may recall its delegates at any time for a breach of duty or for a violation of the instructions provided, end quote. It's there. Number 8, in many states, their resolutions requesting an Article 5 have explicit limitations on the delegate's authority. And because this is in the resolution, I'm going to read it. Quote, the application is made with the express understanding that an amendment that in any way seeks to amend, modify, or repeal any provision of the Bill of Rights shall not be authorized for consideration at any stage. This application shall be void ab initio if ever used at any stage to consider any change to the provision of the Bill of Rights, end quote. And the last safeguard is that states can pass statutes pertaining to Article 5 convention delegates faithfully following those instructions. For example, Indiana has passed legislation with this provision, quote, a delegate or alternate delegate who knowingly or intentionally votes or attempts to vote outside the scope of the instructions established or the limits placed by the General Assembly commits a level 6 felony. America has a rich history of multi-state conventions, more than 40, over 350 years, never had a single case of a runaway convention, not one, ever. And I've given you some safeguards here to ensure that an Article 5 convention complies with the Constitution. I have to tell you that we are all concerned, and you are too. You're an American. You're an Ohioan. You read the papers, you hear the news. We're all concerned about our future. I got 4 little grandbabies. I'm concerned about their future. I want them to grow up in the kind of America that we have grown up in, to enjoy the same benefits and privileges. And if we don't pull back on some of the things that are out of our control at the moment, we're not going to see that become a reality. I think it is time that we exercise our constitutional rights to restore justice, discipline, and order to our republic. And I'm asking you to help us by supporting HJR 3.
Chairman Peterson, Vice Chair Thomas, Ranking Member Humphrey, and members of the committee. My name is Roger Gibb. I'm from Mason, Ohio, House District 56. So in 2022, the Trafalgar Group conducted a nationally representative survey of American adults. What they found is that 66% of Americans supported an Article 5 convention for proposing amendments to rein in the federal government. Even so, we know that there are people on both sides of the aisle who are opposed to what we're doing. And some of them are under the impression that a convention of states would be dangerous. This fear stems from opposition claims that states can't be trusted to amend the Constitution. They contend that states might try to entirely replace the Constitution or scrap some or all of the Bill of Rights. Now, to put this in perspective, let's just imagine that you go skydiving with a friend, okay? You both get up into the airplane, you jump out together, and after free falling for a couple of minutes, you realize it's time to release your parachutes. So you reach back and you both pull that strap, but nothing happens. Parachutes don't deploy. You both panic for a minute and then you remember your training. You've got a second parachute in your backpack. So you reach back to deploy that second parachute, but your friend screams at you, "Don't deploy it, it's too dangerous." Confused, you look down at the ground, it's coming up very fast. You look back at your friend, and you say, "The second chute is there in case the first chute doesn't work. It's for our safety. Do you have a better idea?" Your friend looks back and says, "No, but don't do it, it's too dangerous." Now, I know that sounds absurd, but that is pretty much what our opposition says about this effort. We, the American people, we're the parachutists, and we're faced with a very dangerous situation. Our federal government is literally bankrupting our country, among other things. And Congress is the first parachute. And if Congress were listening to we, the people, they would propose reasonable amendments like a balanced budget amendment. But Congress refuses because Congress is part of the problem. Now, our second parachute is for states to propose amendments. Yet our opponents say, no, that's too dangerous. Do they have a viable alternative? No, but they're insistent on stopping us from deploying our proverbial second parachute. Now, we know from previous experience that in upcoming committee hearings, you're going to hear claims from our opposition that proposing amendments to the Constitution via Article 5 is too dangerous. At the end of the day, you're all going to have to decide what to do with that. Convention of States and the people who are testifying before you here today, we rely on a team of nationally acclaimed attorneys to help ascertain and confirm the safety of the Article 5 process. Two of our most prominent attorneys are Michael Farris, whom you've heard from today, and Robert Nadelson. Since you already have met Dr. Farris, I will tell you about Robert Nadelson. So he is a law professor of 25 years. His research has been cited repeatedly at the U.S. Supreme Court, federal appeals courts, and state Supreme Courts. He's widely acknowledged to be the nation's preeminent scholar on the Article 5 process, having written the only legal treatise on this subject. So I hold his book in my hand, The Law of Article 5. He is the author of no fewer than 40 articles on the Constitution in peer-reviewed legal journals. 5 of those articles were published just in the past 13 years, specifically on the Constitution amending process. Now, collectively, Michael Farris and Robert Nadelson have written more than 300 pages. Okay, I have them printed here, front and back, 300 pages in legal journals over the past 13 years to specifically debunk claims from our opposition that somehow following the legal lawful process of Article 5 is too dangerous. Now, because these writings were peer-reviewed, they were rigorously evaluated by other constitutional experts for historical accuracy, 2 centuries of Article 5 usage, and a long line of Article 5 court decisions extending from 1798 to the present century. And so in conclusion, when you hear and read opposition testimony in the upcoming committee hearings, we urge you to evaluate their claims that following Article 5 of the Constitution is dangerous against the following two criteria. First criteria, are their claims simply statements of opinion, or have they been vetted by real constitutional experts through the peer review publication process of legal journals like the writings of Michael Farris and Robert Nadelson? Criteria number two, are their sources contemporary, meaning are they from this century? Put more simply, is their material outdated? This is important because our opposition likes to cite sources from the 1950s, 60s, and 70s, when activist judges and professors favoring big government made unfounded claims to stop states from amending the Constitution. If so, these claims have very likely been debunked by the 21st century scholarly writings of Michael Farris and Robert Nadelson. So putting it simply, if our opposition can't get their provocative claims peer-reviewed by real constitutional experts and published in reputable law review journals, then I would submit to you that they're not credible and you shouldn't take them seriously. If you hold our opposition to these high standards, what you're going to find is that very few, if any, of their claims are worthy of your serious consideration.
I'm from Beaver Creek, Ohio, House District 70, and I will today discuss one of the pillars of the Convention of States movement, which is imposing fiscal restraints on the federal government. And I will do this by analogy. When a person seeks to get their finances under control, there's three things that they need to do. And I've been in this situation before. The first thing is to stop taking on new debt, unless it's an actual emergency. The second thing that you do is you pay off your debts to reduce the amount of interest that is flowing out of your budget. And the last step is then to get into a better situation where you are prepared for those emergencies and you don't need to go into debt ever again. Let's consider the federal government situation. There is a debt ceiling, but it is more fictional than real. It is a political football. The second thing, to pay off debts, there is no plan that I've ever seen where this federal government is ever planning to pay off its debts, much less get it under control. And saving for future emergencies, I want to bring that up. During World War II, the ratio of debt to GDP was lower than it is now. If we wanted to fight another world war, we would be in a very tough financial situation at this moment. I highly encourage you to allow this to go to the House floor for a vote. There have been surveys over nearly 40 years that on average, the people of the United States support a balanced budget amendment by high margins in the 70s. This can pass. This is realistic. And as Dr. Farris mentioned, a single subject rule in combination with other amendments from the list of topics that are germane to the convention could present a realistic way forward for us to get the finances of the federal government under control. And one last thing to consider, the psalmist of the Bible stated, quote, "The wicked borroweth and payeth not again," close quote. That is, in my opinion, the way that the federal government is operating. We are printing currency and hoping that that is going to fool our debtors into believing that we plan to pay off our debts, but we have no plan. And it is up to us, the people in the states of this country, to bring this government under control.
Vice Chair Thomas, Ranking Member Humphreys, and members of the committee. I am Susan K. Dunn from Westchester, Ohio, House District 45. I am a supporter of Convention of States and HJR 3. One of the frustrating things that I have experienced in my time with Convention of States is how opposition has stood up in hearings like this one and used only partial quotes to mislead the committee. Today, I want to address one of the false claims that they have made before and will probably make again. It is the claim that the late Supreme Court Justice Antonin Scalia was opposed to Article 5 conventions. To achieve their objective, our opposition has cherry-picked a statement from Antonin Scalia while ignoring other statements that he made. During an interview with the Kolb Report in 2014, Justice Scalia was asked the question, if you could amend the Constitution in one way, what would it be and why? He responded saying, quote, I certainly would not want a constitutional convention. I mean, whoa, who knows what would come out of that? Then Scalia continued to speak. Yet opposition ends their quotation of his comments right there. They want you to believe that when Antonin Scalia said he would not want a constitutional convention, that he was referring to an Article 5 convention for proposing amendments. At first blush, it's not clear what he meant when he said constitutional convention. Was he referring to an Article 5 convention for proposing amendments, or a constitutional convention for writing a whole new constitution like the one held in Philadelphia in 1787? Perhaps we can gain a clue from the rest of his statement. Here is his entire statement. Quote, I certainly would not want a constitutional convention. I mean, whoa, who knows what would come out of that? But if there were a targeted amendment that were adopted by the states, I think the only provision I would amend is the amendment provision. I figured out at one time what percentage of the populace could prevent an amendment to the Constitution, and if you take a bare majority of the smallest states by population, I think something less than 2% of the people could prevent a constitutional amendment. It ought to be hard, but it shouldn't be that hard, unquote. The full quotation makes it clear that Antonin Scalia supported amending the Constitution. In fact, he thought it should be easier to amend the Constitution by the states. This paints a very different picture. This suggests that when he was opposed to a constitutional convention, he was actually referring to a convention like the one in Philadelphia in 1787, not an Article 5 convention. Please note that our opposition will use the term con when they're actually referring to an Article 5 convention for proposing amendments. There have only been 2 constitutional conventions in U.S. history, the one in 1787 and one in 1861 for the Confederate Constitution. Our opposition's use of con causes confusion and reinforces the mental image or fear of a junta, not merely to propose some amendments, but would rewrite the entire Constitution. Don't be fooled. This is intentionally and totally misleading. For additional clarity on Antonin Scalia's true opinion, we can look to a 1979 panel in which he participated. This was at the time of the balanced budget amendment drive. Regarding Article 5 convention specifically, he said, quote, the Congress is simply unwilling to give attention to many issues which it knows the people are concerned with, which issues involve restrictions upon the federal government's own power. I think the founders foresaw that, and they provided this method in order to enable a convention to remedy that. If the only way to get that convention is to take this minimal risk, then I think it is a reasonable risk to be undergone. I suggest if the only way to clarify the law, if the only way to remove us from utter bondage to the Congress is to take what I think to be a minimal risk on this limited convention, then let's take it, unquote. Antonin Scalia's own words. My testimony has included only this one example of our opposition partially quoting a historical figure or quoting them out of context in order to make it appear that they were opposed to Article 5 conventions, when in fact, the opposite is true. We see that the opposition's claim is a lie. a lie by omission.
Good afternoon. I am Teresa Ford from Chillicothe, Ohio. I've been a volunteer for Convention of States for about 5 months. Thank you for allowing me to present to you today my testimony in favor of House Joint Resolution 3. I stand before you today to urge a vote and passage HJR 3, which focuses on supporting a balanced budget, establishing term limits for federal legislatures, and for limiting the overreaching power and jurisdiction of our federal government. All three of these issues are important, as poor decisions by career politicians and greed create instability in our economy, business growth, and productive future for our local communities, state, and nation. Luckily, our founding fathers made a path for us to rein in the government through Article 5 of the Constitution. On January the 20th, 2021, an executive order was issued revoking the permit on the Keystone Pipeline, resulting in thousands losing their job. My 67-year-old brother was one of those whose job was affected. He now travels to Brazil to do the same job he was doing in Oklahoma. He has faced hardships such as traveling during the pandemic, added expenses, burden of being away from his wife and family, armed banditos who wanted what he has, and violence, to name a few. We are now seeing high fuel prices normal citizens can't afford, a government wanting to push electric vehicles that are expensive and not reliable in cold temperatures, plus a reliance on foreign countries such as China and the Middle East for oil. This is unacceptable. My father, who's 93 years old, served in Korea aboard the USS Kishwaukee, an AOG-9 tanker. He survived war. He survived the Oklahoma City bombing. He survived 3 heart attacks and cancer. He worries too frequently about not getting his Social Security checks and payments due to government shutdowns. This too is unacceptable. Please help us take back control of our country. What is happening currently is unacceptable. I sincerely hope you will consider and pass HJR 3. Thank you for your attention, and God bless America.